back to the channel. This is the House of Law. So you're thinking about investments, where to put all your money. You may have considered buying property, and that's a great idea. But you're also thinking, do I really need to own one? In other words, at the back of your mind, you're also considering just leasing property and enjoy all the perks of ownership without the ownership, so to speak. Many people are fascinated with buying and acquiring property because, after all, property is an asset and it increases your net worth. But having a high net worth may not be your priority. You might just want to have the flexibility and none of the stresses that ownership entails. So today I will talk about lease. What is a contract of lease? What are the rights and obligations of the parties? Is it really better than buying property? All that in this video. So let's begin. There are two types of lease of things and lease of services. But in today's video, we will only talk about lease of things. So in a contract of lease of things, one of the parties binds himself to give to another the enjoyment and use of a thing for a price certain and for an agreed period not exceeding 99 years. In a lease of things, the owner of the property merely transfers temporary use and enjoyment of the thing. There is no transfer of ownership. So the owner or the lessor continues to be the owner of the property, but he has to respect the right of the lessee to enjoy and to possess the property. A contract of lease is a consensual contract. In other words, it is perfected by mere consent. So the lease is binding even before the property is delivered to the lessee. As a general rule, a contract of lease is effective only between the parties. But it can also bind third persons if the lease contract is annotated on the title, so that anyone who wants to check and verify the status of the property will find that there is an existing lease contract and the property is in the possession of the lessee. Another common feature of a contract of lease is the right of the lessee to sublease the property. But this right to sublease may be expressly forbidden by the lessor in the contract. This is to make sure that the property is only used by the lessee and only for the purposes originally contemplated. So what is the best way or form of executing the contract of lease? Well, a contract of lease is valid and binding whether it is oral or in writing. But if the property is registered land and for the protection of the lessee, it is best that the contract of lease is in writing so that the contract can be recorded with the registry of deeds and annotated on the title of the property. Now let's talk about obligations and rights of the parties. Let's start with the lessor. As a lessor, it is your obligation to deliver the thing in such a condition that is fit for the use intended by the lessee. So if the lessee leased the property as a residence, then it should be fit to be used as a home for the lessee and maybe his family. The second obligation is the obligation to make necessary repairs. And these necessary repairs are needed for the maintenance of the property, such as electrical repairs and maybe plumbing repairs. And lastly, it is the obligation of the lessor to respect the right of the lessee and to keep the lessee in peaceful use and enjoyment of the property. How about the rights of the lessor? Well, the lessor has the following rights. First, the lessor is entitled and has the right to be paid rent. That is, after all, the reason or consideration of the lessor in leasing out his property, to be paid the compensation agreed upon in the contract for the use and enjoyment thereof by the lessee. Next, he has the right to be informed of any usurpation or untoward acts committed against the property by a third person. Third, he also has the right to be notified of the need for repairs. And lastly, the lessor has the right to receive the thing at the end of the contract or when the lease contract is terminated for whatever cause. Now let's talk about the lessee. As for his rights and obligations, these are simply the counterpart or the opposite of the rights and obligations of the lessor. So first, the lessee has the obligation to pay the rent in the amount and according to the schedule stipulated by the parties. Second, the lessee has the obligation to notify the lessor of any usurpation or untoward acts. Third, also it is his obligation to notify the lessor of any need for repairs, whether necessary or useful. And lastly, he has the obligation to return the thing or leased premises after the termination of the contract or when the contract is terminated by mutual consent of the parties. Now, in addition to these traditional obligations, it is well to remember that the lessee has the obligation to use the thing or devote it only for the use and purpose contemplated by the parties. So if the property is leased as a residence, it cannot be used as a commercial establishment without the consent of the lessor. Now also, it may be stipulated in the contract that it is the lessee who will pay the real property taxes. For after all, by its nature, these real property taxes are imposed on the use or occupation of the property and not always on the ownership of the property. Okay, so those are the obligations of the lessee. As for the rights of the lessee, well, in relation to the obligations of the lessor, the lessee has the right to receive the thing in a condition fit for the use or purpose for which it was leased. Second, the lessee has the right to necessary repairs of the thing. And lastly, the lessee has the right to be respected in his peaceful enjoyment and use of the thing for the entire duration of the lease contract. Now let's talk about termination of a contract of lease. The first ground is the expiration of the contract on the date and time agreed upon by the parties. Well, there are also other grounds or reasons for rescinding the contract, meaning terminating it before its expiration. These are non-payment of rent, violation of other terms and conditions of the contract, devoting the property or altering the use of the property, and in case the property needs very important repairs because the continued use of the property may pose hazards or harm to the dwellers of the property. In addition to those grounds and reasons for rescinding a contract, the contract of lease may also be terminated by order of the authorities because of some local ordinance or local government issuances that were violated by either the lessor or the lessee, such as those involving public health, public safety, and even public order. So these are considerations and are deemed integrated into the contract of lease. Now I have a question. What happens to the improvements introduced by the lessee in the leased premises, such as buildings, structures, fixtures, maybe even equipment attached to the leased premises? Well, the Civil Code provides that the lessor has two options, and he alone can exercise which of these two options. First is the lessor can appropriate these improvements by reimbursing the lessee with half or 50% of the value of these improvements. Now, if he doesn't want to appropriate these improvements, then he can allow the lessee to remove these improvements, provided that the removal of these improvements will not seriously damage the leased premises. So there you have them, the standard provisions and requirements for a contract of lease. These are standard provisions because they are what the law provides, but the parties can supersede and modify these provisions. So for example, in their contract, the lessor and lessee can stipulate that it is the lessee who will assume the obligation to make the necessary repairs. Also, they can stipulate that the improvements introduced by the lessee will go to the lessor at the end of the contract without reimbursement. Okay, so these provisions or these stipulations are legal and can be included in the contract. Now to the question which I posed in the beginning of this video. Should I buy property or should I just lease property? Well, leasing has its benefits. Number one is flexibility. It affords you the flexibility of changing addresses anytime depending on your priorities, depending on your needs, depending on your work. Second, leasing does not entail the same responsibilities as property ownership. Remember, property ownership is imbued with public interest. So as an owner, You do not only answer to your seller, to yourself, but also to the public, to the community. You don't have those worries as a lessee. Your only worry is when and how to pay the rent. Now, of course, if you are one who wants to put your money in the best place, then buying property would be the best investment. Because remember, property values appreciate. Now, if you continue leasing properties, you will never see your investment. Also, owning property assures you that you have something to leave behind to your family, to your children once you pass. So, clearly, those are your considerations. If you want flexibility, then choose leasing. But if you want legacy, then buy that property. So that's it for now. Thank you very much for watching. I hope you learned something valuable today. Please give this video a thumbs up if you enjoyed it, and please don't forget to subscribe and click on the notification bell for future and upcoming videos. Again, thank you and see you in the next video.